there in Senegal. But let's take you now to quite a strange story this time in Nigeria. The legal team of detained leader of Indigenous People of Biafra, IPOB, that's Nnamdi Kanu, yesterday. Now, they staged a walkout as the Federal High Court sitting in Abuja commenced its proceedings on the 7-count treasonable felony charge the federal government preferred against him, Nnamdi Kanu. Now, let's take a listen to what his team of lawyers had to say concerning what happened yesterday in the court.
Let me just make it very clear. Ohanese delegation came to this court. The traditional rulers sent a large delegation to this proceeding. The former governor of Anambra is here. All of them are outside the gates, being harassed and being disgraced. And I've been standing for 2 hours. I'm talking of men in their 80s, some in their 90s. I am the lawyer to Ohanese. I am outside and I could not go in. So where is the justice of this case? Where is the trial? I was brought up to learn that a judge sits independently and that justice must not only be done but must be seen by all to have been done. So today there is a problem.
It can't be done.
This is not a political.
You can't adjourn the case without being discussed.
So.
And when we are here, it can't be done. She could have just adjourned it for 1 week. She's supposed to hear from us. She's supposed to hear from us before adjourning the case. We are here. The courts are here. We are just outside it up, and we were locked out. And our books and law reports, our backs are inside the court right here. And the courts are where we are outside the court door. You have simply someone even let us to the process. That's the matter.
And said the court was locked. So basically, we were
Well, that's the drama we witnessed yesterday at the Federal High Court in Abuja. So just watch that clip of a group of, counsel
legal team to Nnamdi Kanu to express their displeasure over the refusal by the Department of State Service, that's DSS, from allowing them be in the court premises or inside the court during the proceedings. Now, in a short ruling, though, Justice Nyako expressed a displeasure over the conduct of Nnamdi Kanu's legal counsel. She also came out to give some information about. She also came out to say that she has declined the dismissal of the case, but the case has been adjourned to January 19 and January 20 of 2022 for trial. Now we have joining us constitutional lawyer and public affairs analyst, Barrister C.C. Chukwudi. Many thanks for joining the program, Barrister. Now the trial of Nnamdi Kanu has been adjourned to January 19 and 20 of next year. What do you make of this?
Good morning. I am pleased for having me this morning. I want to say categorically that adjournment was totally uncalled for, particularly considering the nature of the case and the public interest attached thereto. It is a criminal proceeding which, under our law and the current position of the law, which allows for expeditious trial and the hearing of criminal matters in Nigeria. Just about 2 weeks ago, the Chief Judge of the Federal High Court published a practice direction which states clearly that there must be an expeditious trial of criminal cases over and above other cases which may be pending before the Honorable Court. The same was also adopted by the Chief Judge of Nigeria when he was deciding and presiding as the chairman of NJC. So that particular adjournment from November till January 2022 is totally uncalled for, and particularly against the tenets of the requirement of the expeditious trial proceedings, which ought to be accorded to criminal proceedings generally. So indeed, we look at it as something that is orchestrated by non-granting the proper fair hearing and not giving the proper attention to a sensitive case as the case of Nnamdi Kanu. So that is what I make of it.
All right, Barrister Chukwudi, you were a legal luminary yourself. Let's listen to this from one of the lawyers of Nnamdi Kanu yesterday in court. Let's listen to this.
It's enshrined in the Nigerian Constitution. It's enshrined in the International Covenant on Civil and Political Rights. It's enshrined in the Universal Declaration of Human Rights. It's a basic principle of civilization. If you're accused of a crime, you have a right to counsel. And he's been denied access to me 5 times. And I'm here not to be an irritant. There are huge international law issues that are present in Nnamdi Kanu's case. You all know this kidnapping in Kenya, the extraordinary rendition to Nigeria just being one of them. So I'm here because I'm an international law expert to provide more enlightenment on what legal issues are present here. I'm not here to just try to create a problem or to create some kind of irritation. And yet I've been denied 5 times. What am I a threat about? I have not acted in any way that's disruptive. I've been courteous, provided identity that they've asked for, and every single occasion, Mr. Fine, you can't visit him. It's clear that...
All right, Barrister Chukwudi, I'm sure you're quite familiar with Bruce Fein, one of the lead counsels to Nnamdi Kanu and other his lawyers who were there yesterday after they staged that walkout. You are also a lawyer yourself. What do you make of his comments, Bruce Fein, not being denied access to his client and others, even staging the walkout yesterday? Where do we go from here from a legal perspective, in your opinion?
In my well-considered opinion, I think it is enshrined in our Constitution that a person who is being tried or charged for criminal offense has the right of the counsel of his choice, particularly when that offense is a capital offense. He has the right to be provided for a counsel, and he has the right of his counsel of his choice. We can look at it from the provisions of the 1999 Constitution as it is contained in Section 36 of our 1999 Constitution. It's a ground and a fundamental proceeding. In fact, when an accused person has no counsel, and considering the magnitude of the offense, he is deemed to have been denied fair hearing. That is to say that. Now, in considering the position of the foreign lawyer, let me also say, so to say, that if the right to a counsel is subject to the position that that person must be qualified under our Nigerian law to practice.
All right, Barrister Chukwudi, I think we're having a little technical situation there. But Olisa, I mean, just before the lead team came back. Okay, Barrister Chukwudi, are you still there? All right, so now Barrister Chukwudi, his lead counsel, Ifeanyi Ejiofor, who was initially inside the courtroom, also joined in the walkout just before the judge came in. Why would the lead counsel, Ifeanyi Ejiofor, join in walking out when he was allowed into the courtroom initially?
That is where I am a little bit skeptical as to what informs his opinion in taking that decision. Yes, as a lead counsel, what he would have done is to complain to the Honorable Court that some of the counsels who had appeared with him are being denied entry into the courtroom. Yes, he ought not to have gone out. He should have been there and complained directly to the Honorable Court. And the court has it as a duty to grant his request, because when a person is engaged, he should also engage with the lawyers who are working with him. The counsel to the prosecutor may have a counsel, a subordinate one. The SAN may have a counsel, may have subordinate counsel. And that is the right of the defendant who is standing trial. Now, for staging a walkout is where I blame him. I am saying this as a lawyer. He ought not to have left the courtroom knowing that the liberty, the trial, and the sanctity of that particular court is in issue. So it means that he ought to be in court and then complain to that honorable court that there is an obstruction of members of his legal team from coming into the honorable court. And the court can take that particular decision by allowing those persons to come in, not for him to stage a walkout. Because there were sensitive motions which he had already filed.
Right. Now, Barrister, we need to listen to what the lead counsel, that's Ifeanyi Ejiofor. We have this video of what he had to say concerning what happened yesterday. Let's take a look.
So ordinarily, the court should have caught our attention. Come, Ejiofor, let me listen to you. What is going on here? We have more than 8 or 10 officials of SSS inside the court here. The AG, DPP was represented, is also in court, with about 7 lawyers there in court also for the federal government. They said they can only allow about 5 persons only. And we are more than 7 or 8 of us here. We have people representing several groups in here, lawyers. Bruce Fein came flee all the way from the US. Nnamdi Kanu attorney in US and also IPOB attorney. So I've not seen such thing. So the ideal thing for us to do is to go back and re-strategize. Obviously, I don't think we are going to continue with this course. Most likely, we're going to take it off from there, because the court, by virtue of what transpired today, I don't think we still have implicit confidence.
All right, Barrister Chukwudi, we just listened to Councillor Ifeanyi Ojo for himself. Are you satisfied with what he said about the reasons why he also had to follow suit with the walkout?
I listened to. No, I am not. I am not satisfied with his position because according to him, from what I heard he say, is that there were about 5 councils already inside the court. And then he is agitating that there are other interest groups, people from the United States and people from Ohanese, and other people who have come to join by virtue of their lawyers. The question is, the business of that particular day, is it the business that those other lawyers can be called up to address? And the answer is no. It is his motion which is pending before the Honorable Court that he came to address. Granted that no lawyer can be restricted from entering into the courtroom because the trial ought to be in public, and court should be a public place where anybody can come in, provided of course you are still within the rules and regulations governing the courtrooms. So the lawyers cannot be restricted from coming into the courtroom, so also is the audience. But the point remains that the business of the day revolves around the Ejiofor and his team of lawyers who were already inside the court and should have carried on with the business of the day. If you balance the idea of working out and balance the idea of what was to happen yesterday, you see that the one that weighs higher is the business of the day, which concerns its motion challenging the jurisdiction of the Honorable Court. And I sincerely say that he should not have worked out. All he should have done is to proceed and make his complaints clearly before the Honorable Court, so that in the next occasion or during the proceeding, the court may correct the position. But that does not seem so far to grant him that particular temerity to walk out from the Honorable Court when he is already inside the court with his team of lawyers. Because the motion ought to be argued will be the motion which is filed, the motion which is challenging the court, and probably a motion for bail. And those motions are ripe for hearing. And you can imagine what happened. The counsel on the other side, which is the prosecuting authority, asked for the dismissal of that particular motion because he appears that Nnamdi Kanu lawyer was not ready for the proceedings. So it is a technical approach which he misfired. But we are saying that the Honorable Court ought to be informed that lawyers are at liberty, complete latitude, to be in the court, irrespective of whose trial is going on.
Right. Well, Barrister Chukwudi, always such a delight to have you on the program to really break down this from a legal perspective, analysis and insight. Well, thank you once again, Barrister C.C. Chukwudi, constitutional lawyer and public affairs analyst, for coming right here on Breakfast Central. So we wait January 19th and 20th next year when we'll have Nnamdi Kanu once again in court.
Thank you very much. It is my pleasure. Thank you.